Hello everyone and welcome to today's webinar, IP Protection Strategies for Original Equipment Manufacturing in China, a session brought to you by the China Ipr Sme Helpdesk. My name is Ben Roberts. I'll be your moderator for today's webinar. Joining me shortly will be our presenter, Deanna Wong, who will take us through today's topic. But before we hear from Deanna, let's take a moment to familiarize ourselves with the webinar platform itself. You should be able to see the control panel on your screens. You can use this to interact with us throughout the webinar by typing questions and comments into the question pane. Our support team, Alexandra and Kinga, will be on hand to receive those questions, so please feel welcome to write to them and send all your questions in. We will either ask your questions directly to Deanna during the presentation or save them for the Q&A session at the end. Please note that we can unmute your microphones if you would like to ask your question directly to Deanna yourself. Let's do a quick sound check to see if you can all hear me. Please can you all click the raise hand button on your control panel now. I'll give you a few seconds to do that. Yes? How's it looking, Alexandra? Good? Okay, great. One final point. We are recording today's webinar and it will be available to download from the past webinars section of our website in the following days, along with a copy of this presentation. Before we move on to the main presentation, please let me briefly introduce the China Ipr Sme Helpdesk for those of you who are not so familiar with the project. We are a project funded by the European Union, and as such our services are free to all European small and medium-sized companies and European business organizations. We provide jargon-free, first-line, confidential advice on intellectual property issues in China to European businesses. Our main services include an inquiry helpline, which allows you to ask IP-related questions and receive a reply within 7 working days. We also offer training events, which are held throughout the year across Europe and China. We also offer IP training materials, such as guides, newsletters, and a case study catalogue, which are all available to download from our website. You can also find interactive e-learning modules, a news section, and information on our upcoming events on the website. As well as these services, you can also connect to us on social media networks such as Facebook, Twitter, LinkedIn, and our blog, Your IP Insider. Okay, without further ado, let me introduce you to today's speaker, Deanna Wong. Hello, Deanna. Thank you for joining us today. Perhaps you could tell us a little about yourself and then we can move on to the main presentation.
Sure, thank you very much, Ben. I'm Deanna. I'm a partner of Hogan Lovells and director of the agency that Hogan Lovells has. Okay, and I've been practicing in the area since 1999 and I first qualified in New Zealand and I've been working in this area for more than 10 years now.
Okay, thank you, Deanna. Are you happy to run through the agenda for us before we launch our first poll?
Okay, sure. The agenda today is really on issues that surround OEM manufacturing in China, and we sort of look at a few issues which include how to preempt and to prepare for these issues and have a few case studies. And at the end we'll also go through some of the contractual terms that you might want to think about before you start OEM manufacturing in China.
Thank you very much. Okay, we'll be launching our first poll. Okay, the question is, do you currently manufacture products in China? Okay, A, yes, B, no, or C, plan to. Okay, we'll give you a few moments to vote on that. How are the results looking? Are the results coming in?
Yeah.
Okay. Few more seconds, and okay, we've closed the poll. Deanna, perhaps you could give us your verdict on the results. So we've got 40% saying yes, they do manufacture in China, 40% saying no, they do not, and 20% planning to.
Right, actually it's slightly lower than what I anticipated. I thought probably a lot more than 40% would be involved in manufacturing in China. Perhaps some of them are actually service providers maybe, which may explain why the slightly lower percentage.
Okay, thank you. We'll move on to the main presentation now.
Okay, right. So the presentation today is on intellectual property and OEM, and so some of the issues that we'll come across will be familiar to some of you, but may not be to the others. So what we'll start off with is probably a summary of some of the jargon, if you will, of some of the terminology that I will use just to familiarize everybody with it. The first one is, what is intellectual property? And there are a number of different types of intellectual property. And the most obvious one would, for example, be a trademark, which may be, for example, Nike or McDonald's. Those are marks or brands that people are familiar with upon which you buy products, for example, or services. The second one is really copyright, and copyright is probably the most easily explained by, for example, copyright that people own in a particular book, or when you take a photo, or when you actually do a piece of art. That is all copyright that you own. And leading to that, it also includes web content, etc. The other type of intellectual property, which a lot of people will be familiar with, is, for example, your domain name. That is also a property that you own that is intellectual property related. Likewise, similarly, company name, it's also a proprietary right that a company or a person owns in its own company name or its own personal name, actually. The last two, which I'll briefly just say what they are patents. Patents are, for example, what you know of at a more basic level. For example, for a drug, there is going to be a patent associated with it for the chemical compound, for example. Or it might be a design, for example, for the design of a cup. That is also a design patent. Or a utility model, which is a simple form of an invention, which may be, for example, a zip may be considered as a utility model, depending on the design. And then, obviously, the last but not least is obviously trade secrets, which is also part of your intellectual property. Now, unlike some of the ones that we've talked about above, trade secrets is something that is not really registrable. You don't go and apply to register a trademark for yourself. You don't go and apply for a trade secret for a company name like you do. So trade secrets are something that is proprietary to you that you don't want other people to know about. So, for example, the formula of Coca-Cola, if you will. Right. So the next slide sort of tells you how the whole IP, how IP rights and its importance fits into the big picture. There are sort of many layers of different types of intellectual property rights, which goes through right from the individual to the organization, to the university, to the SME, locally, and also internationally. As IP rights become more important because of internationalization of the world, it is inevitable that countries will have associations with each other based on their citizens' intellectual property rights, if you will. So that just sort of shows you how it fits into the world globally. The next slide sort of talks about the vocabulary that people should understand when we talk about OEM manufacturing. Most of the people that have joined online, I would presume, would know what OEM stands for. It stands for Original Equipment Manufacturer, which in its basic form means you subcontract, or not subcontract, you actually ask another entity to manufacture products for you, okay? So in the most basic level, it will be when a European company, if you will, ask a Chinese company to start making chairs based on the European company's design or its drawings, okay? The products are then usually shipped overseas, or in particular also sold in China. That is also possible. And so the manufacturer who is involved in that process, which is namely a China manufacturer, is what we call the original equipment manufacturer. And these agreements that should be signed between the European company and the Chinese manufacturer are what we call OEM agreements. Another area that sort of this touches on, this whole area of OEM manufacturing touches on, is non-disclosure agreements. So non-disclosure agreement is what we use in a lot of circumstances whereby before you want to disclose your idea to another person, and that person can be your OEM manufacturer, can be your trade future partner, can be someone that you want to outsource a particular design feature to. These people should really first sign a non-disclosure agreement before confidential information is shared with them. And so aside from an OEM manufacturing agreement, the non-disclosure agreement is also something that is important for people to consider. The next vocabulary that I've got there is injunction. Injunction is something that I'll briefly mention here. We probably won't get a chance to cover it during the course of this presentation, but it is one of the remedies that a company can try to seek in the event of an infringement. It is not easy per se, but it is available as a remedy in China. And then another terminology that I may mention is dispute resolution, which basically talks about what are your rights in the event of a dispute between the parties who are involved in an OEM type agreement, or indeed any type of dispute that results from intellectual property violation. Right. Okay. So the next slide basically shows how the possible IP would flow in, and also how it could affect the whole supply chain. So what usually happens is, the intellectual property owner from Europe would have the IP ownership, and they would have certain types of protection. What happens is, depending on the arrangement with the supplier, if the European manufacturer doesn't protect itself adequately with the use of the NDAs or the OEM agreements that we talked about, or does not have intellectual property rights that are properly and adequately protected in China, what usually happens is there could be a lot of infringement that would take place, whereby the supplier would start supplying things backdoor. So it would have obtained all the information from the IP owner, and then it starts producing products for itself instead of for the European brand or the IP owner per se. And what usually happens to this is, as a result of this, I suppose, unauthorized manufacturing of products, what could happen is it would obviously affect the brand's equity, the goodwill that the brand would have internationally, and it would also eventually, maybe in certain situations, lead to product liability issues, whereby people think that a certain product is actually manufactured by a particular IP owner, when in fact it's not, and it's counterfeit or fake product or backdoor product of an inferior quality. So these are some of the issues that can come into play in OEM manufacturing. Now, some of the things that a lot of you would have heard about that relates to OEM manufacturing probably generally falls within these four big buckets. The first one is obviously counterfeit, which basically means your fake products, which is something that we've talked about before. And then the other one that a lot of people will be concerned about would be copying or knockoffs. So these would be ones whereby similar products are made, but they don't really look and feel exactly the same, but they just generally look similar. They may not use exact branding, but overall it gives you the impression it comes from the same source when it doesn't. So these are called knockoffs per se. And then the other thing that a lot of people would have heard about is probably about trade secret theft, where the brand owner provides often a China party some of the trade secret which relates to its proprietary product or its proprietary process, and the Chinese manufacturer or the Chinese party would simply take the trade secret and start manufacturing things him or herself, or start improving on it and surpass the original IP owner. That would be called the trade secret theft. And then the last but not least one, which people hear horror stories about, are about brand hijacking generally, which also can extend to other types of IP, which basically means that the party with the bad faith would take your trademark or your IP of any other sort and pretend to be it is their own, and apply and register for it in their own name in China. And this obviously leads to a large amount of difficulty, and also would eventually lead to a bit of litigation as well in the event that the brand owner decides to recover it. Right. Now, before I go on, I just wanted to ask Ben, so how, in terms of timing, how are we looking for timing in terms of the time I should be stopping for questions or?
For the presentation itself, we still have around 25 minutes more, and that'll give us time for a question and answer session with the audience at the end.
Right, okay. So in terms of how to identify the issues, there's actually a lot of materials here. So I will try and go through them quite quickly, and then thereafter the slides are always available and people can download or ask questions afterwards. One of the things that is always, people always say to me is, okay, we want to involve an OEM manufacturer. What are the first things that we need to do? And the first thing I would say to them, well, actually, before you even embark on a China presence, I would say one needs to think about looking at what type of IP it really should have protected in China, and having a look at whether or not sufficient preemptive measures have been taken for that. And that includes, for example, making sure you get the appropriate trademark design and copyright protection that you would want to use in China. And a lot of times, a lot of clients don't go through that motion, and by the time they come to us, it is often too late. Now, we understand for a lot of SME, the cost prohibitive factor often makes it difficult for them to have a comprehensive type portfolio before coming into China. However, one should bear in mind that if things do go wrong, it is important that you have at least some basic protection. So we always encourage clients to say that, look, you may not get the platinum version of IP protection, but you need to at least have the basic one. And there are many ways of doing it cost effectively, but it's really in a matter of turning your mind to it and making sure you do the necessary preparation before you embark on discussions of manufacturing in China, etc. Okay, right, so this goes back to what it is. Okay, now, in terms of what we said, one of the things that a lot of people often say is, what if some of our IP rights are not actually protected anywhere, actually, and some of it is really a trade secret? I have a secret way of manufacturing Coca-Cola that will be very popular. Now, only I know how to do it. How do we protect it? Now, we discussed it earlier on, and one of the things that we mentioned is you need to ensure you sign an Nda Agreement, which is called a non-disclosure agreement, and this needs to be signed before you actually disclose that trade secret. And this is something that clients always kind of forget, especially small SMEs, and they think, well, look, no one's going to agree to it, so why give it to people to sign? The issue is, whilst people may not sign it, there is actually a good chance that a lot of companies are more familiar with these now, and they will sign it. Secondly, while it's a non-disclosure agreement, will not be watertight per se, because in terms of enforcement, it does sometimes have issues. It is still better than not having anything signed at all. Right, so the next couple of slides talks about filing trademarks in China, and I won't sort of talk about this in a very great detail. Suffice to say, it is an area that you need to think about if you were going to start OEM manufacturing in China, because effectively one of the issues that we're going to talk about in one of the case studies is if you don't apply for the trademark, someone else will. So you need to ensure that before you do OEM manufacturing, you at least turn your mind to getting some of your more basic trademarks registered. Right. Now, aside from that, one of the things that clients also say to me sometimes, and this is not as directed to OEM manufacturing per se, but it is also relevant, and I think I should mention here, is whether or not when clients decide to embark on a presence in China, whether or not they would think that they need a Chinese trademark. And most of the time they would say to us, no, we don't need one, and then we're just going to proceed with our global presence in China using our English marks. Now, the reality of the matter is in China, most people speak some people speak good English, but a lot of people probably do not appreciate English branding the way that overseas people do. And as a result of that, you probably have better market access if you use some Chinese characters for your trademarks. And that's sort of something that needs to be considered when you enter China. Now, some of the marks that we have so far, and usually if we had more time, we will go through a Q&A part and see what you would recognize. But here I'll just quickly say what they are. The first one is McDonald's. So as you can see from the picture, for McDonald's, they call themselves 麦当劳 in China. They obviously use McDonald's and people do recognize it, but more importantly, when they launched in China, they had already decided what Chinese name they were going to use in order to protect the brand integrity. And secondly, also to educate the public that that is what their brand is going to be known as, and correspondingly they can file appropriate trademark registrations to protect themselves from it. The next one is Prada, which probably doesn't sound very nice, but anyway, that's Prada's Chinese name, Prada. And then the other one is Baoma. So Baoma means precious horse, and that's for BMW. And I think they get it from the sound of the B, etc. And then the other one at the end is Sprite. Now, Sprite is interesting. They've chosen to use a combination. They've chosen to use a name that's Xuebi, which has got nothing or no sound allusion to Sprite at all, but it does connote the idea of coolness, okay, and of enjoyment. So that's the one that they've chosen to use. So some companies, we do suggest if they decide to embark in China, they should look at a Chinese trademark if appropriate. Obviously, if it's purely from an OEM manufacturing point of view, when you're using a company to manufacture a particular product for sales for overseas, this becomes less important. However, I would warn that for most of the times, clients think that they're only involved in OEM manufacturing, but before they know it, they would ring us up and say, well, actually, someone set up a shop selling our products in China using another Chinese name that people refer to us as. And that's when you will have a problem trying to recover it if you do not look at the Chinese mark initially at the beginning. Right. So the next slide basically shows you how many trademarks are there and how it is comparable to other countries. And it will show you that, for example, China is by far one of the largest country whereby it's got the highest number of trademark applications and published marks. And you can show it, and you can see that that clearly shows a trend that the importance of people placing on IP protection in China has grown quite a bit over the years. And as we see it, it will continue to grow, albeit it may not be at the same speed as it once has, simply because a lot of brand owners are already here. But we do see there will be growth in that generally, nonetheless. Okay, right. So, one of the things that we've always heard clients say to us sometimes is, in OEM manufacturing, one of the concerns that a lot of clients have is if another company starts to make their products and starts to sell it overseas, whether or not there is a way to stop it. And some of these may be exported overseas. Most of them will be exported, for example, in Europe or in the US. And the clients would say to us, we know they all come from China. How can we possibly stop them? And then what we usually say, which goes back to what we mentioned before, there is something that can be done. And if we're just looking at the customs itself, what we can do is record the client's rights at customs, whereby customs will try and assist and cease any inbound and outbound shipments of infringement goods. Now, this is only possible if you first have trademarks in China or indeed any IP rights in China to start with. And if you do not, it will be virtually impossible to ask customs to assist you in stopping counterfeit products from exiting or entering China. Right, and this is just another slide which demonstrates how widely spread China is in terms of seizure of goods generally internationally. Right, and therein lies our case study 1, and this case study is a fairly typical one, and basically what it actually says is a European manufacturer decides to start cooperation with a Chinese manufacturer. They sign no contracts, which is fairly typical, and the European company doesn't have trademark registrations in China or in Europe. The European company, after a little while, decides, well, maybe it's worthwhile to look at the China market. They try and apply to register in China, and then they realize that their OEM manufacturer partner, Zhongkou, had already applied for it a long time ago when they first started the cooperation. So then, in these situations, what usually happens, and how do they actually get resolved? Well, first of all, the European company usually gets quite angry by it because all of a sudden the China entity will have the power to do anything, including stopping their products from export or import. And now what happens is the European company will be infringing arguably its own IP rights and will be pretty much chained to this China manufacturer, Zhongko, until they resolve the trademark issue, or alternatively the European company decides that they can simply rebrand. Okay, so this is a fairly typical case scenario, and it does happen all the time. Now, in that case scenario, if you are lucky and the China company trademark hasn't been processed or registered yet, then you can try and stop their mark from getting registered, and by that you have to file an opposition. But it goes back to what we were saying before. It would be better to preemptively have made sure that you have some basic protection in order to prevent someone from taking your IP rights from you. Now, before I go on, just wanted to check if there are any pertinent questions that we can answer some of them now, just so that I know how to adjust the speech moving forward.
Okay, thank you, Deanna. We do have one question based around the vocabulary that you introduced earlier. The question is, does OEM refer to a foreign company manufacturing in China only for export, or for both export and domestic sales within China? This question comes from Alison from the UK.
Right, I think OEM manufacturing actually refers to anyone that sells products that are not made by themselves. So it's regardless of whether or not there's a China angle to it. If you are asking someone else to manufacture products for you to sell, then by definition that is already OEM manufacturing, per se, regardless of domestic or export purposes, really.
Okay, thank you. And this question comes from Jan from Germany. If I don't register a trademark in China, but decide to manufacture without registering a Chinese trademark, am I safe? And I think this touches upon the case study you just presented to us.
Right. I mean, when you look at these questions, you consider it from both an offensive and a defensive point of view. If you are only manufacturing a product in China and you brand it elsewhere, then arguably you would not have the problem of the mark being hijacked by someone else on the provision that you do not care about the China market itself, and you don't mind that someone else sells the exact product under your mark in China. And as a result of that, you would have lost sales that arguably you would have been able to get. That's number one. Number two, as we had discussed at the beginning, IP rights actually do not just cover trademark per se. So if you were looking at IP rights generally, you should also consider, for example, your patents and your design. In theory, if you can safely say one doesn't really care about ever making any sales in China for the trademark, nor does it intend to use any IP rights that it has in China, then that statement probably is true. However, I would think that that would be a rather short-term view of the whole thing rather than a long-term strategy for the company and for the product itself moving forward.
Okay, so it would be certainly key to register a trademark as a preventative measure. Okay, great. I don't think we have any other questions on that subject just for the moment. I'll pass the mic back to you, Deanna.
Okay. Right, so the next slide just says, okay, going back to the scenario that we had, so in this particular case, when the European company has its trademark stolen, what could it have done? And then hindsight, and these are the things that, you know, I know hindsight is a great thing, but there are a few things that you can prepare for it to make sure, prevent you don't have this happen to you. So, for example, in this particular case, always do due diligence on your OEM partner. As with any relationship, you should really know your counterpart as well as you can. Have the due diligence on them to the extent that you can. I know it's always very difficult for SME who are sourcing products or sourcing manufacturers for China, but usually go for someone with a good word of, someone who has been referred to you because someone else has used it and through word of mouth, and someone that you trust has actually good things to say to them. And also, if you can, make sure that you have a check on them and see if they are historic hijackers of people IP rights, and that's not very difficult to check online. It'll give you an idea. Also, like we said, make sure you protect yourself to start with when you come into China with respect to your IP to the extent that you possibly can. Also, if you were concerned, and and this would probably be more relevant for larger clients, is looking at whether or not you need customs to assist. And the last one, which is about OEM manufacturing contract and non-disclosure agreements, are the documentary side of things, which we would suggest or companies have in order to protect itself moving forward. And an OEM agreement, contract, and non-disclosure agreement are not difficult documents to have in place, and you should really have that to the extent you can. Right, so the lessons from the first scenario is really OEM manufacturing does involve due diligence. It involves a long-term trust arrangement, and you should really only disclose information to someone that you trust. And secondly, you need to make sure that you're adequately protected yourself, both from an IP registration standpoint and also from a documentary standpoint. And with that, I'm going to move to poll 2 and pass you further to Ben.
Thank you. Okay, so poll 2 for us is, have you signed any agreements with business partners in China? A, yes, B, no, C, planning to, or D, only with some of them. We'll give you a few seconds to give your answers to that question. Okay, a few more seconds. Okay, we're going to close the poll. So, Deanna, in answer to that question, we've got 50% of people who have signed agreements with their business partner in China, 13% who say no, they have not, 13% who are planning to, and then 25% saying with only some of their partners. What would your advice be on signing agreements with business partners? Is it a completely essential thing to do?
I think my question would go to the people that signed that actually voted for actually voted for D, when they only said only with some of them. So I presume that there is a measure that they decide whether or not it is necessary, depending on the importance of the actual relationship and the product that's being made. And obviously, OEM manufacturing agreements, they may be a difficult subject to broach for certain people, but for a lot of times it is important that you have some sort of agreement in place. And one should make sure you have that in China, and they should be properly documented and executed in order to ensure that it can be enforced to the extent that it can be.
Okay, thank you, Deanna. Okay, we'll go on to the next part of your presentation, OEM related to contracts.
Right. Okay. So the next few slides will talk about the OEM agreement specifically, and also the non-disclosure and also licensing agreements as well, to the extent that is necessary. Now, so one of the issues that one would think is, how do you approach companies to sign these? Because a lot of times it's very difficult to sign it. That is true. Now, you have to sort of decide if the party that you're working with refuses to sign it, all or any of the above, then what quite is going on? And it may be sometimes they use a whole lot of excuses, and it may be, look, we don't understand English, we can't read it properly, or the chief representative isn't here, or it's too long and it's too convoluted. So my advice for that will be, regardless of that, you should still try and get at least a very simple one executed, especially a non-disclosure agreement. You have to bear in mind that unless you have a document like that, once you disclose something that is arguably a trade secret to you, to another party, without having signed a non-disclosure agreement, it's virtually very, very difficult to stop them from using it to their own devices and exploiting it to the extent they want to, without taking into account your profitability or anything that happens to your own business. So this is something that, while this may be a difficult subject to broach, it is something that one needs to deal with if one is going to be involved in China OEM per se. Right. Now, NDA agreements are important because one of the things you have to also be aware of is once you sign an agreement with somebody, you're not really just signing an agreement with one particular individual. You're actually signing and trusting all your intellectual property or trade secret really to anything that has anything to do with that supplier, which may include its employees and would also include arguably the customers. For example, if you have a mold that you kind of leave lying around in the OEM manufacturing's factory floor, which happens very often, and another one of their clients for another particular product sort of walks down the factory one day and he sees your mold. Okay, now that by itself means that you are exposed to those customers also taking away your IP. So as part of the NDA, you need to make sure you also have in place more practical measures in order to ensure that you can protect your IP rights to the extent that you can. For example, we have clients that would ensure that the molds are kept in a different location, and they would need it locked, and access will have to be restricted by certain individuals only, and they specify that in the OEM manufacturing agreement to a large extent. Also, in some circumstances, the clients actually own the mold, and so for a lot of so that means that they keep ownership of it and they keep physical custody of it to the extent that they possibly can. Right. So with respect to NDA, I think we sort of went through what could be the worst case scenario and what are the risks that's associated with it. Primarily it's to deal with if someone steals it. And also, like what we said, you're looking at a large number of players that can come into NDAs or come into trade secret violation. Suppliers, ex-employees, disgruntled employees, competitors, and these are all very common issues that associate themselves with OEM manufacturing. One needs to remember that even with an NDA, stealing of trade secret is difficult to enforce. Without an NDA, it is very, very difficult. So now, in terms of what are the provisions that should be included in an NDA as a minimum, these are the things that you probably need to be more aware of. It should really be signed before you send any documents over, including copyrighted drawings, including engineering drawings, including CAD drawings. You should really do that before, but you should really have an NDA signed before you send that. And obviously a lot of clients will say, but we need to get cost quotes, etc. But there are many ways of getting cost quotes without sending the OEM manufacturer your crown jewel, just to get a good idea of it. And you can do it after they've signed the NDA, so that is not a problem. A lot of clients would often have an NDA that to us is based on, for example, US law or European law and is in English. Okay. Now that, from an enforcement standpoint, will have a very difficult or will actually increase wiggling room for the manufacturer, whereby they can claim they didn't really look at it, they don't really understand English, and it's not really signed by the legal representative. These are the things that all really you need to be aware of, that in the event you need to rely on an NDA, the NDA needs to be properly executed and should be kept very well guarded in the event that you need to bring it out for enforcement. It should have dispute resolution procedures. What happens if things don't go right? And it may be by arbitration, or it may be by the court system. And most of the time, clients like to have contracts based on overseas law. But the truth of the matter is, in the event you try to enforce such a document in China, it is not that easy to do, and it will usually, more often than not be to the overseas entity's interests to do so. Right. And now, in terms of the things that an NDA should say, it should really control a number of things. First of all, it should restrict disclosure as to who can the information be disclosed to. And sometimes it can specify in terms of the actual personnel that should have access to it. And it will also restrict outsourcing, whether or not it can be outsourcing, it can't be outsourcing, it can only be outsourced provided it has adequate authorization, what it may be, and parties can agree to that. It would also restrict them from sharing any potential information, including client lists, including any proprietary information, to any other party. And in certain circumstances, and you have to decide whether or not it is affected by the anti-monopoly law, is sometimes they will have a restraint of trade, which basically restrains the entity or the manufacturer to only make similar products for you and not anybody else. And sometimes, depending on the scope of the contract, some owners are able to demand that from their manufacturing supplier. Right, so that sort of covers NDA for now. Have there been any questions on the NDAs before we move on?
Yeah, thanks, Deanna. We've just received one question from Jasper from the Netherlands asking, when signing an NDA, can I include a time term as forever in the NDA, even though I may only use the contractor for 1 year?
Right. An NDA usually is enforceable provided that that information is actually held as a secret for the duration. So, for example, you say to someone you're not allowed to disclose it to anybody, but in fact that information is already readily available online and is publicly available information. So that NDA will no longer be I guess, practical in many ways because that information is readily available elsewhere. But aside from that, there is no particular restriction to say it can be forever. Yeah.
Okay. Thank you. One more question on NDAs received from Louisa from Italy. She asks, does it offer extra benefit if I notarize the NDA in terms of enforcement?
Yes, it does. It would assist quite a lot in terms of enforceability of the contract moving forward.
Okay, thank you. I think those are all the questions we've received on NDAs for the moment.
Right, okay. Right, okay. So the next few slides will basically cover an OEM contract and what particular terms should be in there. Now, we've talked about NDAs, and now the next thing is, okay, aside from an NDA, what else do you need to have in place? And that's an OEM agreement. And effectively, this is what you should really sign after signing the NDA, and you've decided after a certain amount of due diligence and getting to know the manufacturer, you think they are the appropriate person for a long-term relationship, or indeed, at least for some manufacturing, it may not necessarily be particularly long-term. So an OEM agreement is that document that should be signed, and it governs the relationship. And one needs to remember that a lot of clients actually say to me, well, we had a purchase order. Now, a purchase order is very different. A purchase order is actually terms of sales and purchase, and it's really just really just has general purchasing conditions. For example, when will payment be made, how will payment be made, within when is the delivery expected, how will delivery be effective, those types of things. Those don't generally cover other terms within an OEM agreement, and it definitely never covers IP issues related to an OEM relationship. So one thing that has to be remembered is a purchase order is not really an OEM contract per se, and I've also had clients that say to me, is a bill of lading an OEM contract? It also wouldn't really be one either. Now, in terms of recommendations for an OEM contract, now this is something that needs to be discussed between the OEM manufacturer and the party, and obviously with the lawyer as well, preferably. And you know, similar to the NDA, some of the things that you need to be aware of is it should be in Chinese and English, and it should have dispute resolution mechanisms, and similar to what we said before, it should really be signed and sealed at least to the extent and executed by the appropriate legal representative. It should also, in certain circumstances, depending on how big it is, if you'd like it to be, you can also have it notarized if you'd like to be extra safe. In certain circumstances, it may include liquidated damages, but this really should just be a reasonable calculation of the damages, and it shouldn't really be considered as a penalty amount. So it should just be a good amount as opposed to having a ludicrous amount of, say, $5 billion for damages that won't be enforceable. But if you have a reasonable amount that is specified there, that would usually be okay. Again, it's probably more practical to have Chinese law applicable as a law applicable, though I do understand some companies still prefer to have overseas laws, but then you'll need to consider whether from a practical standpoint that would help if you need to enforce it during the course of the agreement. Okay, now some of the things that an OEM manufacturing agreement would also have is it would quite often, for protecting itself, it would actually say the OEM manufacturer cannot really deal directly with the customers, and indeed in most circumstances, and if at all possible, I guess a lot of European companies would try to avoid letting the OEM manufacturers know the details of their customers to protect themselves. The OEM manufacturer also needs to govern who owns the mold, who owns the design, who owns the associated IP related to it, because obviously as some R&D gets done, and it may be very minor amendments to a CAD drawing or whatever, it needs to be clear who would still own the IP to that moving forward. And it should be the European company as much as one can, and that needs to be specified in the OEM contract preferably. There also needs to be penalties on non-return of molds, breaches of contracts, and there should also be a penalty on, for example, backdoor sales. And one thing the client also has to consider is what type of monitoring it will have in terms of making sure the OEM manufacturers are compliant with this, whether or not there will be regular audits, whether or not the European company has the right to turn up within, say, a 12-hour notification period, or just turn up in certain circumstances. That needs to be discussed. Also, in terms of the practicality of how to control the manufacturing of backdoor products, etc. Slightly more innovative ideas would be, for example, to control the number of labels that they get access to consider controlling the amount of fabric that they have for a particular type of garment, or to actually monitor, or to get someone to make sure they monitor how many pieces of clothing gets manufactured on any given day, and that may be through investigators or what have you, just to have a regular audit. Obviously, for some of these measures, it would really be more relevant for larger manufacturers, but there are also certain things that the smaller manufacturers can do, and some of them are, for example, to be present, at least make sure you have continued communication with the OEM manufacturer, and that you are aware of what they're doing and they are aware of what you're doing. And that can be very simply by face-to-face meetings and just seeing them, or it may be by making sure you own the molds and you have someone on the ground who can assist you with certain things, etc. Right, so the next scenario that we have, the next case, is a case study whereby it talks about an OEM manufacturer signs a OEM manufacturing contract with the European company. The contract is written in English with a translation provided by the Chinese company specifying arbitration in Hong Kong. The European company also provides all the molds and designs for the Chinese company to ensure of the quality. Now, what happens is, after the European company decides to terminate, the China company refuses to return the molds. Okay, and not only that, it starts carrying on backdoor sales. Now, this is fairly standard in terms of issues that we face all the time. And again, this is, to be honest, this is completely a run-of-the-mill complaint. So now, if the OEM manufacturer decides to keep it, the European company needs to get the molds back, which goes back to our question of sometimes it is very sensible to have access and ownership of the molds to the extent that you can. Practically, it may not be feasible, but some clients have managed to do it in some more practical ways. Now, what the client will need to do in this case is probably something that's not nice. You have to file a case in the court, try and get the injunction, and try and force them to transfer the molds to you, as well as get the sales back to you. Now, that's usually what we would like to do. Now, whether or not that is possible on a more practical level, that is the question. Now, some of the things that can go wrong with this is when you try to enforce it, first of all, the other side may say, well, the English translation has nothing to do with the English version, and indeed we've had situations whereby the parties who signed the agreement, the English or the Chinese, just do not match, and indeed the Chinese entity doesn't really exist, or the person who signs it is really just the janitor of the company, so, and doesn't bind it. So these are some of the things that you need to be aware of before you rely heavily on your OEM manufacturer agreement. So in this particular case, in hindsight, what the European company could have done is a variety of things. It could have had control and make sure it reviewed the translation. It would probably be a benefit if they continue to monitor them somewhat, and also try to control subcontracting to the extent they can. and also having the law being based in China would have been useful rather than having a dispute resolution clause that specifies Hong Kong, making it difficult for them to actually enforce from a practical standpoint. So, okay, so I think that was sort of some of the things that we discussed briefly, and that summarizes some of the OEM issues and the agreement issues that people need to consider. So with that, I think that is basically the crux of the presentation today. Now the rest of the slides actually have a few wrap-up parts and also talk about enforcements, and it also has the poll. Now I defer to Ben as to whether or not there's time to do that or whether or not he'd prefer to do some questions.
I think we've got another 5 minutes for the presentation, so there will be time to cover briefly the remaining slides.
Okay, are there any, just before I move on, because I think that was the last part of the slides on manufacturing agreements per se, so it might be good to go through maybe poll 3 to start with, which is the poll here.
Okay, so poll 3, which we're just about to launch, is if you're involved in original equipment manufacturing in China, have you experienced IP-related problems? A, yes, B, no. I'll give you about 10 seconds or so to get your vote in. Okay, so the results are showing that a third of our audience have experienced IP-related problems. 2/3 have not so far. Would you find that a surprising proportion, or?
No, actually, I'd be interested if the 1/3 would like to write back to sort of say what type of problems they were encountering, whether or not they were similar to the ones that we had. Yeah. Okay. So maybe
Okay,
I can
great.
go through some of the questions.
Yep. Okay. The first couple we have here are relating to NDAs again. We've had a few more questions in since. First is, how much does it cost to notarize an NDA in China? And that's from Julia from Spain.
The notarization would need to should actually take place when the NDA was being signed, and that would mean you'd have to get a notary to certify that, and depending on the region, that cost would range, and it depends on whether or not you can find a notary who's willing to do that.
Okay, thank you. And this is from John from the UK. Should an NDA be notarized in both a European country and China, and is this possible?
I think if the NDA is going to be enforced in China, then it's really just the China side that is more important to be the notary rather than the European side.
Okay, thank you. We also have another question from John from the UK who asks, can you explain the Madrid Convention regarding trademarks in China? If perhaps just a brief overview, and we can then direct John to our guides, which has information concerning the Madrid Convention.
Right, okay, so the Madrid Convention is, as John will know, is an agreement whereby people file international trademarks and they get extended to China. China is one of the designated countries that is covered by Madrid. Now, how, and I guess in many ways for a lot of clients that may be a cheaper way of ensuring its trademarks are covered in China. However, depending on the trademark, it sometimes is beneficial to also have a domestic registration. And also, I would say that if you were hoping or wanting a guarantee that, you know, because you have a Madrid registration, it would be able to prevent anybody else from registering the same mark in China for slightly similar products, my answer to you would be that may not necessarily be the case. One of the slides that I didn't go through in detail was about the trademark filing system in China. It uses a subclassification system, which is slightly different from a lot of places in the world, which means that when you actually try to use Madrid to cover yourself in China, it may not give you as broad a protection as you thought it did initially.
Okay, thank you. And we actually have another question from Kalle from Sweden along those lines, asking, is the international registration system cheaper than national registration in China one by one?
Right, and this is a question that sort of is similar and is trademark related. I think if I can go back to the slide, which probably makes more sense, so you'll have to bear with me if it looks convoluted, at least for now, because I've got to find the slide. Sorry, it was this one here. Yeah, okay. So the trademark system has 45 classes, and in China they divide these into subclasses. What it does is it actually means what you think you'll have it covered is not actually covered. So if I name a very simple example is, say you use your international registration, which covers, for the sake of argument, clothing, and that's clothing, headgear, and footwear. You use that specification and you try to extend that into China. Okay. Now, what would happen in China is you have a extension of the IR that covers clothing, headgear, and footwear. But what you will find is someone's got the same mark for registration for pajamas. And then you'll come in and say, well, why is that not covered? The reason is because the China subclassification system that's used means that whilst you'll be able to get protection in China using Madrid, it will not necessarily prevent anybody else from getting it. Now, if you're one of the OEM manufacturers that just say, look, provided I have something, I'm okay, then international registration can save you a bit of money. However, if you are also of concern that, well, I don't want anybody else to have it, then you might want to spend a closer look to look at whether or not it's worthwhile filing a domestic application as well.
Okay, thank you, Deanna. Perhaps if we go through the final few slides of your presentation before we answer the remaining questions. There are still a few that have been coming in, and possibly more coming in right now as well. So yes, if you take us through the takeaway messages.
Right, okay, that shouldn't take long. So these are just some of the things that we've covered. We've covered an NDA, we've covered OEM and the importance of those. Also, we've mentioned how important it is to try and make sure your IP is registered. So it doesn't just quite relate to trademarks, and a lot of OEM manufacturers, and for a lot of smaller SME clients, it may be a technology, it may be a design type of IP. For example, they've designed an amazing cup that just pours itself or something. In that particular case, it may not be a trademark that's important. It may actually be the design that you need to make sure you adequately protect it, or indeed the patent. Now, in terms of other things, once you've got those agreements signed, one of the things that you need to make sure is you need to have continued communication with the OEM manufacturer, and you need to ensure that, you know, when you come to China, you go and visit them, you kind of monitor them, and you kind of need to keep them on your keep them on their toes. Also of importance is, from a practical standpoint, make sure you do know what you're doing. We've had situations whereby clients subcontract to an OEM, the OEM then subcontracts to about 10 other companies, and the client knew nothing about it. And these 10 other companies started manufacturing exactly the same products for themselves. So these are issues that you need to be aware of and monitor when you start involving OEM manufacturers in China. And I think those are sort of the main things that we wanted to wrap up today. And then we'll go through the other questions if there are any more.
Absolutely, thank you. Perhaps this first question from Jessica from the UK. Jessica asks, is there a way of finding out whether a company has been involved in trademark hijacking if the case was resolved outside of court?
You could probably get an idea if they are trademark hijacker just by looking at how many trademarks they own. If they own 2,000, then chances are they probably are.
Okay, thank you. Then next we have, related to this perhaps, is what should I do first if I realize that my Chinese partner registered my trademark without my knowledge?
That's an interesting one, and it depends slightly on the circumstances and the relationship with the Chinese partner. I would say, you can try and entice them and say, oh, look, I think it's very kind of you. I think you've applied for my trademark. It'd be good if you could get it back because my boss is on my back, and see what they say. And then if they are good about it, they may act sheepishly and give it back to you, or they may not, and you know where you stand by then.
Okay, thank you. If we just will go through the last remaining section of your presentation, and then we'll have I think we've got time for one or two more questions to wrap up, and then we'll wrap up the webinar.
Okay, sure. So I think these are the hopefully these are the take-home points that you all have understood from our brief presentation. Make sure you identify the IP, prepare a strategy, have a think about who you want to have an OEM manufacturing relationship with. Hopefully you would have done some due diligence on them and be monitoring them often. Now, when you look at registering trademarks, like we've sort of said, don't just think of the trademarks. There are sort of other IP rights as well that you need to be aware of. And aside from a brand, it's actually a bit more than that. If you decide that you've found issues with it with your OEM manufacturer, some of it may be a bit of negotiation or a bit of finessing, and you can try and recover it. Other more serious ones, you might need to involve litigation, and then unfortunately you'll have to then consult a lawyer.
Okay, thank you, Deanna. So we'll wrap up with our final remaining questions. This first one is from Alex from Belgium, who asks, what is a reasonable amount for liquidated damages in China? And he wants to ask the same question for penalties for other breaches of contracts. Are these damages always monetary?
Right. The reasonable amount for liquidated damages, that is completely governed by the relationship. I mean, if you use a $5 billion contract, for example, that would affect the liquidated damages. The liquidated damages should really be a reasonable amount of damages that would be reflective of the relationship that you have. If you have a $500,000 relationship, then probably something akin to $100,000 would be reasonable. Something akin to $2 million would probably be slightly more impunitive per se. And for other breaches, yes, it doesn't have to always be monetary. It can be specific performance as well. The issue is specific performance at times may be difficult to enforce.
Okay, thank you. We have another question going back to trademarks on how long does it take to register and how much does it cost?
How long does it take? It depends. It probably from 1.5 to 2 years. How much does it cost? It varies depending on the number of classes that you want to file, but roughly speaking, they should really rather be an affordable amount generally to make it worthwhile.
Okay, thank you. We have maybe one final question that has just come in on the chat pane. Sorry, one moment. Yeah. This is about arbitration councils here in China. Are there any that are perhaps more recommended or more experienced so far in arbitration cases in China? Are there any particular ones that you would recommend?
Right. Quite often people use CETA arbitration, and that seems to be quite a reasonable one that most people widely use in a lot of contractual terms now.
Okay. Thank you very much, Deanna. I don't think we have any more questions on the question pane. No? Okay. So, Deanna, thank you very much for your presentation. Unfortunately, it is all the time we have for today. We will, of course, follow up with you directly if there are any questions that we didn't have time to tackle. If you have further questions relating to OEM in China or indeed any aspect of IPR protection and management in China, please do not hesitate to contact us by email. The address is question@china-iprhelpdesk.eu. You can also call us on 0086 106462 0892. Office hours are from 9 a.m. to 6 p.m. Monday to Friday. We also have an upcoming help desk guide, which is it's a guide to IPR enforcement in China for EU SMEs. Keep your eyes open for that one, everyone. You'll be able to find that guide, along with many others, and all the resources mentioned today on our website, www.china-iprhelpdesk.eu. There is plenty of useful material on the website, so please do go and browse it. You can also stay connected to us through our Facebook fan page, China Ipr Sme Helpdesk. You can follow us on Twitter at IPR China, and join our LinkedIn group, China Ipr. If you're looking for some midweek viewing, please visit our YouTube channel, Helpdesk TV. Those videos there are also available on Tudo. Last but not least is our blog, www.youripinsider.eu, which covers IPR and business developments in China for European companies. You can subscribe to that for the latest post. For anyone who is also interested in business and IPR protection and management in Southeast Asia, we would recommend you visit www.ASEAN-IPRhelpdesk.eu. You can also ask questions through that website about protecting your IPR in Southeast Asia. Okay, that's all we've got time for today. Thank you to all the attendees for your time and interest in today's topic. Many thanks once again to Deanna for today's presentation. The presentation PPT and webinar recording will soon be available on the past webinars section of our website. You can also visit the upcoming events and webinars section for full details of future Helpdesk webinars and events. Thank you. We hope to see you at future Helpdesk events. That's it from us today. Goodbye and 再见.